Hiya! Hiya! Welcome. It's day 14. Cheers, clink. Real estate school. Free real estate school. If you're watching on Zoom right now, we are going to get the Spanish translation started here in just a minute. For all of you on the back end right now, tuned in, waiting to get that started. I'm just playing with you, Christian Tikas. Christian is here. He is translating the class into Spanish today. Normally, Andres de Arense is here. He has the day off, taking care of some stuff. Yes, family. Daniel, Mikey, Lika, good morning. The office is filling up. Amy is here. Deanna is here. And we have day 14 of real estate school. So thank you guys for tuning in. If you are just tuning in, if today's your first day, you don't have to wait to get licensed to start finding and identifying people who need to buy and sell real estate and start earning commission. Yesterday we talked about the WAG game. Good morning, Daniel. Yesterday we had some new people in the office. Gino came in here. Mikey, his first day in the office. It's good to see you. I've got flyers for you. We've got another busy day. We've got Kelly Urso is going to come in here to help with Commission Boot Camp. We've got some drop-ins. Romeo's going to come in a little bit later to see us. And so if you are interested in joining us, feel free to open your laptop and get started for Commission Boot Camp. Commission Boot Camp starts every day at 10 o'clock right here in the French Valley Hub in the French Valley Village Center and at home on your laptop. You stream this live directly to Facebook instead of going to Zoom. And then we urge you to just jump in and get started working. Nobody can wait to get paid. We don't have that luxury. So it is, Christian is now here with us. So I'm going to go ahead and get this class kicked off. Welcome to day 14. This is your free real estate school, your free real estate education at our community. We're going to jump into chapter 49, the right of survivorship. Chapter 50, the Lis Pendens. Chapter 51, preliminary title reports. Chapter 52, title insurance. Chapter 53, automatic and declared homesteads. Chapter 54, conventional financing. Good morning, Christy. Good to see you. We're going to read pages 323 to 365. Of course, if you're following along at home in your book, if you're doing your reading, if you're signed up, you've already enrolled with calpaces.com and with First Tuesday to get access to your discounted code, which is 6106. Get signed up with those classes, $102.55, and then that way you could start working towards getting your real estate license and not getting a 25% commission, but 100% of your commission. So that is the goal, right? That's the goal, that's the goal. All right, so let's kick this pig, shall we? All right, this is chapter 49. We're jumping into the right of survivorship among co-owners. What is vesting? A vesting is a method of holding title to real estate. Differences in the type of the vestings present different consequences for persons who have the interest in property. I'm going to split those marbles out of my mouth here really quick as we're getting started. Title to real estate in California is held in one of four basic vestings. Joint tenancy, ownership of fractional interest in real estate by two or more individuals, each holding an equal share with the right of survivorship. This is, most of the time you see people taking title as joint tenants. When a joint tenant dies, the interest is eliminated and the surviving joint tenants share the remaining ownership equally. Joint tenants take title together on the same deed at the same time, hold equal shares in the ownership of the property, and each has the right to possess the entire property, known as the four unities. 2. Tenancy in common. Tenants in common may have varying percentages of ownership in a property, may take title at different times, and have centralized rights of possession. If a joint tenant conveys their interest in the property to another person, that person takes title as the tenant in common. A tenant in common may will their interest in the property to others on their death, since a tenancy in common interest carries no right of survivorship with it. Or number 3, community property. All property acquired by a married couple in California during a marriage is presumed to be community property unless acquired as the separate property of either spouse. Under the community property vesting, the ownership interests are equal. Community property with right of survivorship. Identical to the community property vesting, but with the inclusion of words creating the right of survivorship. On the death of a spouse, the surviving spouse automatically becomes the sole owner of the property. Continue below for illustrations of the different types of vesting in the application. We'll get to that here in a little while. Vesting reflects estate planning. Consider a married couple who, with the assistance of their agent, locate a real estate agent they intend to purchase. Or not a, excuse me, they don't locate an agent they intend to purchase, but real estate that they intend to purchase. They will use monies accumulated during their marriage and a new purchase assist mortgage to pay the purchase price. The agent, as part of their due diligence on any property acquisition, asks the couple how they want to take title on the close of escrow. The couple wants the property to be vested in both of their names, a married couple with the right of survivorship. On the death of a spouse, the couple wants the surviving spouse to automatically become the sole owner of the property, avoiding probate procedures. Recognizing the community property aspect of their funds accumulated during marriage, the agent advises the couple they need to take title as a married couple, as community property with right of survivorship, or a married couple as joint tenants. The agent explains the two vestings are identical for future conveyancing, since both vestings may be severed before death by either spouse to provide for an alternative distribution of each spouse's ownership interest to others by will, a trust agreement for another vesting of their interest, and on death of the title is cleared of the deceased spouse's interest by the surviving spouse's recording an affidavit declaring the death of the deceased spouse and attaching a certificate of death. However, mindful of the tax consequences of the surviving spouse, the agent recommends the couple vest title to the property as community property with right of survivorship. Like the tax consequences of joint tenancy vesting by spouses, the surviving spouse is assured a fully stepped up cost basis for the community property. In this example, the agent's advice to vest the property as community property with right of survivorship satisfies the couple's estate planning needs for holding title to the property. Likewise, since the property was acquired during the marriage, it is considered community property even if the couple vested the property in their names as joint tenants. Additionally, the couple intends to avoid probate procedures on the death of a spouse. Both right of survivorship vesting avoids enforcement of any contrary provisions in the will of the deceased, since no interest remains under either vesting to be transferred by will or otherwise after death. Community property with the right of survivorship. For the surviving spouse, a community property vesting with the right of survivorship is superior to a simple community property vesting. This is the case even though a simple community property vesting without the right of survivorship also transfers the property to the surviving spouse. If the deceased dies in estate with no will, or testate with a will, stating the surviving spouse takes the property. On a simple community property vesting, if no one can test the surviving spouse's right to become the sole owner of the deceased spouse's interest in the property, the surviving spouse needs to wait 40 days following the death before the property can be sold, leased, or encumbered, just in case their spouse returns to life. Snuck another one in about people being zombies and coming back to life. Got to do that every once in a while. Keep you guys on your toes. No, in all seriousness, this is important stuff to learn. People always talk about how I'm teaching the boring stuff, but how many real estate agents know how to advise their clients on how to vest interest in a property, how to take title, et cetera, and so forth, without just saying call up your escrow officer? Okay, here we go. On a simple community property vesting, if no one can test the surviving spouse's right to become the sole owner of the deceased spouse's interest in the property, the surviving spouse needs to wait 40 days following the death before the property can be sold, leased, or encumbered. After 40 days, if no one has returned to life, an affidavit by the surviving spouse is recorded to clear title by declaring the death and attaching a death certificate. A joint tenancy recommendation by the agent produces the same transferability and tax results as does the community property vesting with the right of survivorship. They function identically before and after death. However, joint tenancy provides spouses with more flexibility by allowing for avoidance on some community debts during the marriage and on death. This avoidance of debts incurred solely by one spouse is not available under either community property vesting. The four unities. Although although most joint tenancies are created between a married couple, a joint tenancy can exist between non-married persons. Conversely, community property vestings available to married couples or registered domestic partners. Did I turn the page? I did turn the page. There we go. Married couples wording the grant deed investing. Oh, I don't want to get into that. We're going to go and skip that little block. You're not going to have to write a paragraph. Additionally, the number of joint tenants is not limited to two, as is married couples' ownership of community property interest. Using one deed, any number of co-owners can take title to real estate as joint tenants. The only ownership condition is that joint tenants take equal ownership interest in the property. Traditionally, the creation of a joint tenancy requires the conveyance of 4 unities. Unity of title, meaning the joint tenants take title to the real estate through the same instrument, such as a single grant deed or court order. Unity of time, meaning the joint tenants receive their interest title at the same time. Unity of interest, meaning the joint tenants own equal shares in ownership in the property. And unity of possession, meaning each joint tenant has the right to possess the entire property. Today, a joint tenancy vesting is loosely based on these 4 unities. For example, a joint tenancy is currently defined as ownership by 2 or more persons in equal shares. Thus, the joint tenancy co-ownership incorporates the unity of interest into its statutory definition. Similarly, a joint tenancy needs to be created by a single transfer to all the co-owners who are to become joint tenants. Thus, the historic unity title of the same deed and unity of time, simultaneous transfers, required under common law have been retained in one event. Typically, this is accompanied by recording of a conveyance transferring title to all of the joint tenants, creating a joint tenancy. A joint tenancy ownership in real estate may be created by any of the following transfers if the conveyance states the owners may take title as joint tenants. A transfer by grant deed, quitclaim deed, or assignment from an owner of the fee, leasehold of life estate to themselves and others. A transfer from co-owners as tenants in common to themselves, or a transfer from a married couple holding the title as community property, tenants in common, or separately to themselves. For the small percentage of joint tenants who are not a married couple, typically family members or lifelong friends, a valid joint tenancy is created when all co-owners take title under the same deed as joint tenants without stating their fractional ownership interest in the property. Their actual fraction of ownership, if severed or transferred to others, is a function in the number of individuals who took title as on joint tenants. For example, 5 co-owners as joint tenants each hold 1/5 or 20% fractional ownership. And really quick for everybody here in the class and for everybody on Zoom and for the one person on Facebook who's watching at home, probably while educating their kids at home learning or whatnot, there is book smarts and then there's street smarts, right? There is the what they're teaching in the book, and then there's the practical wisdom of actually having been out there and having an EQ. So IQ and EQ, that's commonly how we refer to this sort of stuff. Now, when I was teaching machine gunnery in the United States Marine Corps, I would tell people, now, I can teach you the way that the book wants me to teach it to you, or I could teach it to you the way that you need to learn it in order to stay alive, right? So there's the book way of war, and then there's the actual way of war. And so a lot of this stuff you have to learn in order to get out into the streets, right? You can participate in commission boot camp if you're in California. You can generate leads as a finder unlicensed, but ultimately the goal is to get you licensed and get you into the game. And in order to do that, you have to get through this stuff. You have to retain it long enough to get past, so that you could join the first 2 people that got licensed right here in our community real estate school, James and Fred, just a couple of days ago. Okay, we're going to go ahead and jump right back in. However, the necessary incident of a joint tenancy vesting is the right of survivorship, legally referred to as just accrescency. The right of survivorship is a case law doctrine which is triggered by the law of a joint tenant. Thus, the joint tenancy vesting by the incident and the right of ownership, survivorship, becomes operative only on the death of a joint tenant, at which point the right of survivorship extinguishes the deceased interest and leaves the remaining joint tenant with the entire ownership interest they held as joint tenants. The right of survivorship is a mere expectancy held by each co-owner and is not property right. Well, 1 second here really quick. I need to pin myself on the Zoom so that it makes it a little bit easier for Christian to read this stuff. Sorry, Christian. There we go. Make that font a little bit bigger for you, sir. Okay. Thus, the joint tenancy vesting ultimately on death of all other joint tenants, the last survivor becomes the sole owner of the interest in the property originally owned by all of the joint tenants. So if you are holding on to property with a bunch of other joint tenants, you just have to be the last man standing. Vesting alone does not transmute community property. On a dissolution of a marriage, all property acquired jointly by a married couple during their marriage, no matter how vested, is presumed to be community property for the purposes of division. Further, the community property presumption for married couples does not only come into play when a couple divorces. All property acquired by a couple or by either spouse during marriage is considered community property unless the couple clearly states their contrary intention to own their individual interest in the real estate separate as property. Conveying community property. As community real estate, both spouses need to consent to the sale, lease for more than 1 year, or encumbrance regardless of how it is vested. If one spouse, without the consent of another, sells, leases for more than 1 year, or encumbers community real estate, and the non-consenting spouse may either ratify the transaction or have it set aside. I'm going to actually talk about that here in a moment because that's one of the things that I've worked on several times with people is dividing assets. And this is a big question that people have about getting their home listed. So I'm going to talk to you guys about that here in one paragraph. The non-consenting spouse has 1 year from the recording of the non-consented to transaction to file an action to set aside the transaction. Okay, so one of the things that people will come to you often if you get, if you become successful in real estate, is they will come to you during a divorce situation. Often it's one spouse who's kind of a little bit ahead of the decision on making, deciding to sell the real estate or has come to terms with it, will contact you, and you have to let them know, hey, listen, I'm a professional. I'm going to represent you and your spouse equally, your partner here in this transaction. If they need to contact me directly, they can. I'm happy to maintain open communication with both of you and communicate everything to them and meet with them separately so that they're comfortable. In fact, we can have your escrow signings separated so that you guys don't have to meet at the same place. I know that this can be very sensitive. And then what will happen is often people will want to complain to you about their spouse. And this is something that you have to maintain these professional boundaries, okay? And they're going to respect you for it, ultimately. Somebody will tell you why they are frustrated about their soon-to-be ex-husband, soon-to-be ex-wife, et cetera, and so forth. And what you'll tell them is, listen, I completely understand that you're frustrated. However, I wouldn't listen to this sort of talk coming from the other party to this transaction. And so I don't want to put them in this situation. I don't want to put you in this situation. So at this point, I have to maintain a professional boundary out of respect for both of you. And I can tell you, 100% of the time, by telling people that you're going to respect their professional boundaries, they're going to thank you for it, and then they move forward. I haven't had it happen otherwise, right? So it's a respect thing, right? And so what people will ask is, can I get my house listed? And I will tell them, we can list your house with one signature, but we will need both to sell the house, right? So if, just understand that they're going to have to consent to the sale of the house at some point or another. And I'm happy to meet with them, right? So one signature, you can list the house. Now that being said, I try to always get 2 signatures before listing a house, if it is at all possible, so that nobody at least have the conversation, right? Actually, to be honest with you, I've never been in a situation where I haven't gotten both signatures before listing. It's just, that's the law. The law is you only need one. Okay. All right, moving on. Encumbering and leasing joint tenancy property. When real estate is held as joint tenancy, vesting is a separate property, as when the joint tenants are not a married couple or when married couples in writing agree their interests are separate property. Each joint tenant can sell or encumber their interest in the real estate without the consent of the other joint tenant we're talking about. Additionally, when the joint tenancy in real estate represents separate property, a joint tenant may lease out the entire property, since a lease is a transfer of possession, and each joint tenant has the right to possession of the entire property. However, consider a married couple who owns community property real estate as joint tenants. One spouse enters into agreement to lease out the property for a term of over 1 year, which the other spouse does not sign. Under the joint tenancy rule, either joint tenant alone may lease out the property. However, under the community property rule, which applies to the property acquired during the marriage, both spouses need to execute a long-term lease of agreement with a term greater than 1 year. Pretty much what I said, but that also applies with the sale. Severing right of survivorship vestings. Every co-owner vested as a joint tenant as a community property with the right of survivorship has the right to unilaterally sever the right of survivorship. The severance by a co-owner terminates the right of survivorship in that co-owner's interest. The separate or community property nature of the co-owner's interest in the property remains the same after severing the right of survivorship from the co-owner's interest. A co-owner unilaterally severing the right of survivorship is not required to first give notice or seek consent from the other co-owner. To sever the vesting, the co-owner prepares and signs a deed from themselves as joint tenant or as community property with the right of survivorship. Back to themselves, on recording to the deed, the right of survivorship is severed by having merely vested the co-owner's interest. The deed vesting title is to include a statement noting the transfer intended to sever the prior vesting. Recording requirement for severance. Recording is necessary to terminate another joint tenant's right of survivorship. The unilateral severances of a joint tenant's interest need to be either recorded in the county where the property is located before the death of severing joint tenants, or recorded within 7 days after the joint tenant's death, if executed and notarized within 3 days before the joint tenant's death. Additionally, the joint tenant may be severed by agreement of the joint tenants. If a written agreement to sever the joint tenancy is signed by all the joint tenants, recording or notarization is not required. All the preceding rules for recording a severance apply fully to the severance deed of a spouse seeking to terminate the right of survivorship held under the community property vesting. The unilateral severance of a joint tenancy terminates the right of survivorship. Without the existence of the right of survivorship, each co-owner disposes of their interest in the property on death as they wish, such as by will or inter vivos trust, or by the severance itself. Although the sale of joint tenants separate property interest in real estate severs the joint tenancy, a lease or encumbrances of the property by a joint tenant does not. All the procedures for severing a joint tenancy are fully available for a married couple to sever the community property vesting, which includes the right of survivorship. Clear title on death by affidavit. When co-ownership of property is vested as a joint tenancy, the death of a joint tenant automatically extinguishes the deceased joint tenant's interest in the real estate. This leaves the surviving joint tenant as the sole owner. However, the deceased joint tenant interest in the property needs to be cleared from the title before the surviving joint tenant will be able to sell, lease, or encumber the property as the sole owner. The new ownership interest of the surviving joining tenant is documented by simply recording an affidavit signed by anyone declaring the death of the joint tenant who was a co-owner as described in the real estate. The interest in the property held by the deceased spouse as community property with the right of survivorship is extinguished by the same affidavit procedure used to eliminate the interest of a joint tenant, except the surviving spouse or their representative is the only one authorized to make the declaration. Once the affidavit is notarized, recorded, and indexed, anyone conducting a title search on the property will have notice of joint tenant's death since the deceased joint tenant is indexed as a grantor. Thus, surviving joint tenants become the sole owner of the property due to the right of survivorship, controlling the vesting of one half. A spouse can unilaterally sever the joint tenancy and community property with the right of survivorship vestings by executing and delivering a deed that conveys legal title to a third party, executing a deed to themselves, executing a written severance of joint tenancy, or executing a written instrument that evidences an intent to sever. Holy smokes. Additionally, the community property interest of a spouse who executes a deed to themselves to sever the title and eliminate the right of survivorship remains community property. Community property cannot be transmuted to separate property without the consent of both spouses or a court order. A severance deed to oneself, terminating the right of survivorship, is not sufficient by itself to avoid passing the property to the surviving spouse on death for community property vested as either community property with the right of survivorship or in joint tenancy. A will needs to be also prepared or a living trust established naming the person intended to receive the spouse's community property interest on death. Otherwise, since in its community property, the property will pass by intestate succession to the surviving spouse as though the severance of the vesting had never occurred. Joint tenancy tax aspects. Tax-wise, the main question raised for a married couple when the surviving spouse becomes the sole owner of what was community property is, what is the surviving spouse's cost basis in the property as the sole owner after the death of the other spouse? The surviving spouse who becomes the sole owner of community real estate receives a fully stepped up cost basis to the property's fair market value, FMV, on the date of the death, which terminated the community property vesting. Thus, the surviving spouse is entitled to fully stepped up cost basis in the real estate previously owned by the community without concern on whether the property was vested as community property with or without the right of survivorship as joint tenants or irrevocable inter vivos, living trust. State law controls how marital property is characterized for federal tax purposes. Federal law is unconcerned with the form in which title is taken, community property. Thus, the real estate owned by a married couple, unless as vested tenants in common, is considered community property for federal income tax purposes. Accordingly, a surviving spouse is entitled to the property, receives a fully stepped up cost basis to the property, FMV, on the date of the other spouse's death. Chapter 49 in the books. High five. Bam! Read it to the high school students. Just read it to the adults. I never have to read it again. Yes! All right, here we go. Chapter 50, the Lis Pendens. Moving right along, family, moving right along. Clouding the title with a notice. Lis Pendens is Latin for pending litigation. More commonly, a lis pendens is called a notice of pending action. In practice, a recorded lis pendens puts all persons on constructive notice that the title or right of the possession of real estate is in litigation. The purpose of recording a lis pendens is to preserve a person's right to the real estate until the dispute with the owner is resolved. Thus, buyers who acquire an ownership interest in property after a lis pendens describing the property has been recorded to take their interest in the property subject to someone else's, the claimant's, right. Without a recorded lis pendens or physical possession of the real estate, the person who claims an interest in the title and possession runs a risk to the owner will encumber the property to another buyer, lender, or tenant who is unaware if someone else already holds an interest in the property. Title or possession to real estate. A lawsuit needs to affect title or the right to possession of real estate to support the recording of a lis pendens. Lawsuits affecting title or possession in real estate include specific performance of an undisclosed transaction or rescission of closed transactions, judicial foreclosure of a trust deed lien by a lender, foreclosure of a mechanic's lien by a construction contractor, cancellation of a grant deed or other conveyance by a prior owner, fraudulent conveyance to be set aside as voidable by creditors, evictions and suits concerning unexpired leaseholds brought by tenants or leasehold lenders, termination or establishment of an easement between neighboring property owners, government declaration that a building is uninhabitable, injectment of a unlawful occupant other than a tenant from real estate by an owner, partition or sale of a real estate by owner, quiet title, eminent domain actions, and divorce proceedings involving real estate. Real estate lawsuits. A lis pendens is permitted in the following lawsuits over real estate: actions by adverse possessors to determine claims to title, actions to reestablish lost land records, actions to determine adverse interest in any liens or clouds on real estate arising out of public improvement assessments, actions by purchasers or the state to quiet title to tax deed property, actions by innocent improvers of real estate against owners or lenders of record, actions on an improvement bond, and actions terminating or establishing an easement except for a public utility easement. The lis pendens process. To record a lis pendens, the lis pendens is required to identify the parties to the lawsuit and give an adequate description of the real estate. While the object of the lawsuit and its effect on title or possession of real estate does not need to be stated in the lis pendens, the objective of the lawsuit is to be stated in the lis pendens for it to be considered an absolutely privileged publication. Editor's note. Blah, blah, blah. No, I'm just kidding. An absolute privilege covers any publication during a judicial proceeding which is authorized by law, including a lis pendens. A publication made under absolute privilege bars a slander of title action against a person wrongfully claiming title on an interest in the property. A technical legal description of the property subject to litigation is not required as long as the property can be sufficiently identified. Notice, by recording and indexing, a lis pendens is properly of record when it is filed and indexed in the county recorder's office of the county where it is properly located. So this is not something that falls on you as a real estate agent. You're not walking the stuff down to title, and you're not filing it with the county recorder's office. What happens is this is title's job. Okay, so this is part of learning about everyone's job in this real estate school is learning what everyone does. Okay, title is sort of like the punter or the field goal kicker of the transaction. They're very underappreciated, unloved, unseen, unless they fumble it at the 11th hour and then they don't transfer title, or they don't record, or they don't realize that there was an encumbrance on the title, a lien, etc. and so forth, that wasn't clean, that had to be clean in order to close transaction. Okay, so your title person is very important, of course, but this is what they do. So recording and indexing a lis pendens constitutes a constructive notice to all persons about the existence of a dispute over title or possession of a property. Any buyer, lender, or tenant who is later conveyed an interest in the property is bound by the final resolution of the dispute. Title insurers and specific performance actions. Title companies usually refuse to insure title when it is a lis pendens is recorded, which involves a specific performance action. Without title insurance, buyers will not buy, lenders will not lend, and tenants will not occupy the property. However, a lis pendens in a buyer-specific performance action does not interfere with the title company insuring a lender's trust deed, which secures a debt in an amount less than the price the buyer will be paying for the property. As a result, property subject to specific performance actions by buyers is often rendered unmarketable while the lis pendens remains in effect. The tremendous value of the lis pendens to litigating buyers is its ability to preserve the buyer's right to purchase the property. The recording of a lis pendens often persuades a hedging seller to perform. Accordingly, the potential abuse of a lis pendens procedure to cloud title of an owner's property is readily apparent. Expungement of a lis pendens. Any time after a lis pendens has been recorded, anyone with an interest in the property affected may file a notion asking the court to remove the lis pendens from the record, calling expungement. An order expunging a lis pendens removes from title any restrictions sought to be imposed by the lawsuit on the transfer of the property. So one of the things that could come up on a title pool that you may not realize might be there is something like a hero loan, right? So a seller gets a hero loan on their property. They establish solar. They get dual, energy efficient windows, an air conditioning unit, all these different things. But what they did was they took it out with an 8 to 11% interest rate on their property a lot of times. And so a lot of buyers don't necessarily want to assume that, because what happens is it shows up as a lien being on the property, and it also increases the special assessment on the property. So if you don't pull title and you're just going out looking at properties, and you're not doing your homework or whatnot, you don't understand the taxes, sometimes you might walk your clients into a situation to where it takes getting into escrow to find out that there's liens on the property. Now some of these liens, and this has happened a lot, and in fact more often than not, a seller will be getting ready to sell a house. We'll pull title on the house just to make sure that it's clean, and a judgment will show up. Now with a common name, like let's say like David Serpa is not a very common name. What's a common name without sounding like John Roberts, right? So John Roberts, or like Hector Gonzalez, or something like that, like where it's a very common name. What will happen is sometimes you'll see like a child support order will pop up, or there will be a lawsuit pending or whatnot against a particular person or a property, et cetera, and so forth. Now sometimes it's as simple as going and finding out that it was actually filed against the wrong person, because their name is very common. And like I said, this has happened several times where, oh my gosh, there's a lien on my house. I had no idea. Oh, it says that it's for unpaid child support or whatnot, right? And then they say, oh, I'm married. I have 3 kids, or I've never been married in my life, or whatever. And it's like, well, clearly that's a mistake then, and the title has to be cleared, right? Okay, anyway, all of that said, Chapter 51. Chapter 50 is in the books. Preliminary title reports. An offer to issue title insurance. A preliminary title report is intended to disclose the current vesting encumbrances which may be reflected on the public record affecting a property's title. Encumbrances reflected on a preliminary title report include general and special taxes, assessments and bonds, covenants, conditions, and restrictions, or commonly known as CC&Rs, easements, rights of way, liens, and interest of others. A preliminary title report, also known as a prelim, is not a representation of the condition of title or a policy title insurance. Unlike an abstract of title, a prelim cannot be relied on by anyone and imposes no liability on the title company. Sometimes, there will be something that shows up later, like what happened when I purchased my house. There was a $400 judgment from the HOA against the house that I was moving into. And anyway, I purchased the house. They hit me with a $400 fine for the back fence not being painted immediately, like week 1. And so I was like, okay, I'm just never going to paint the fence. And I still haven't. And it's been like 3 years. Don't come at me hard. Anyway, no duty to accurately report. A title insurer has no duty to accurately report title defects and encumbrances on the prelim, shown as exceptions in the proposed policy. A prelim is no more than an offer to issue title insurance policy based on the contents of the prelim. Further, the offer may be modified by the title company at any time before the policy is issued. The closing of a purchase escrow is contingent on the buyer's approval of items, and the prelim to set conditions of title consistent with the expectations on the buyer on entering into the purchase agreement. The buyer, their agent, and the escrow review the report for defects and encumbrances on title inconsistent with the terms for the seller's delivery of title set in the present agreement and escrow instructions. They also look for title conditions which might interfere with any intended use or change in the use of the property contemplated by the buyer. Again, so this is actually something that's really important. And so every time I go off on a tangent, everybody tells me, you need to actually teach the stuff that's in the book, or take it off book or whatnot, or why not just not read from the book, give these, expand a little bit, right? And then every time I expand, people drop off, right? Okay, so I saw somebody post in French Valley Talk earlier, and I have a great deal of compassion for them. But they have a ranch or something like that in North Winchester, and they're very frustrated because of all the hundreds of homes that are being built along Washington. Now, we live in a master plan community, right? We live in an area where there are certain areas that are zoned for single family residences, and whatnot. So like the truth is like when you buy a property, it might be on a 20-acre parcel. You might be very excited about that, but it also might be right next to a commercial development, right? And so finding out what the title or what the land is zoned next to you, right? So that's kind of important. Sometimes you'll find that it's BLM land, which is Bureau of Land Management, and so it's never going to be developed. It's never going to be built on. Other times somebody will buy a house and they'll say, oh my gosh, it's totally beautiful. There's nothing behind us. It just goes on forever. And it's going to be a gas station in like a couple of years, right? So like it's important to know not just the title, what's coming back on the zoning for the property that you're purchasing, but also what's coming in the area, right? Because if you weren't paying attention to French Valley and you weren't paying attention to the fact that Benton Road is going to connect to Clinton Keith, and then that's going to only get wider, right? And then Washington is only going to get more busy, and they're going to start putting more gas stations. Anyway, if you don't pay attention to these things when you're buying a house, then of course they're going to come back and haunt you. But at the end of the day, somebody's going to be very happy with a 5-acre parcel in the middle of everything. So if you need to list your house, call me up. Let's do the damn thing. All right. Did we read no duty to accurately report? I think we did. Okay, we're going to escrow reliance. I think we read that. Okay, escrow relies in part on items approved and disapproved in the prelim to carry out instructions to record grant deeds, trust deeds, leaseholds, or options which are to be insured. Typically, escrow instructions call for closing when the deed can be recorded and insured subject only to taxes, CC&Rs, and other encumbrances as agreed to and approved in the instructions. Ultimately, it is the escrow officer who, on review of the prelim, advises the seller of any need to eliminate defects or encumbrances on title which interfere with a closing as instructed. Ultimately, the prelim and a last-minute date down search of title condition are used by escrow and the title insurer to reveal any title problems to be eliminated before closing as instructed, obtain the title insurance for the documents when recorded. The title insurer's date down on the prelim prior to closing may turn up title defects or encumbrances not included in the prelim. These occur by error on the part of the insurer or by recording after the preparation of the prelim. In any case, the title company may withdraw to offer under the prelim. The title company, when issues a new prelim, offering to issue a policy on different terms. So of course, like I said, it's okay if one of these, a title issue shows up. It's okay if you find out that there's a lien on the property. But what happens during the escrow process is that lien is effectively handled throughout the escrow process so that you can receive a clear title on the date that your clients record, okay? So don't be scared off by these things. Don't be scared off if even your clients have these liens on their property. That's why you want to find out as soon as you list the property. Don't wait until you get into escrow to start searching your title, start searching your prelim, okay? Prelim versus abstract of title. Prelims were once compared to abstracts of title. An abstract of title is an accurate, factual representation of title to the property being acquired, encumbered, or leased. Thus, an abstract of title may be relied on by those who order them as an absolute representation of the conditions of title. An abstract of title is a statement of facts collected from the public records. Good morning, Trevor.
Good morning, sir.
An abstract is not an insurance policy with a dollar limit on the insurers. Liability as is set forth in a policy on the title insurance. The content on an abstract is intended by the insurance company to be relied upon as fact. Thus, the insurer is reliable for all money losses of the policyholder flowing from a failure to accurately state all conditions of a title in the abstract they issue. Okay, chapter 51 in the books, Elfin. Moving on. Chapter 52, we're reading to page 365 today, and we've got about 10 more minutes to read 24 pages, which means we're not going to make it. You're going to have homework. All right, title insurance, chapter 52. Identifying an actual loss. A policy of title insurance is the contract under which a title insurance company reimburses or holds harmless a person who acquires an interest in the real estate against a monetary loss caused by an encumbrance on title that is not listed in the title insurance policy as an exception to coverage, and the insured policyholder was unaware of when the policy was issued. Thus, a policy of title insurance is a form of indemnity insurance. Title insurance policies are issued on one of the several general forms used by the entire title insurance industry in California. The policies are typically issued to buyers of real estate, tenants acquiring long-term leases, and lenders whose mortgages are secured by real estate. As in an indemnity agreement, a title insurance policy is a contract. The terms of coverage in the policy set forth for the extent of the title insurance company's obligation, if any, to indemnify the policyholder for money losses caused by an encumbrance on title. Encumbrances unknown and undisclosed. Almost all losses due to the reduction of the value of real estate below the policy limits arise out of an encumbrance. An encumbrance is any condition which affects the ownership interest of the insured. The word encumbrance is all-encompassing. Any right or interest in real estate held by someone other than the owner which diminishes the value of the real estate is considered an encumbrance. Encumbrances on title include covenants, conditions, and restrictions, CC&Rs limiting use, reservations of a right-of-way, easements, encroachments, trust deeds or other security devices, pendency of condemnation, and leases. Property and use not covered. Physical conditions on the property itself are not encumbrances affecting title. Accordingly, the title insurance policy do not insure against open, notorious physical conditions which exist on the property. A buyer is always presumed to have contracted to acquire property subject to known and visible physical conditions on the property which impede its use or impair its value. In the case of encumbrances, recorded or not, no such presumptions exist. Presumptions. Underwriting only indemnifies a loss. A title insurance policy is not an abstract of title, which warrants or guarantees the non-existence of title encumbrances instead of receiving a guarantee of title conditions. The named insured on the policy is indemnified to the policy dollars limits against a money or loss caused by the title condition, not listed as an exception or exclusion in the policy. Under a title insurance policy, the title company only covers the risk of monetary loss caused by an encumbrance which is not listed by an exception or exclusion to the coverage and was unknown to the named insured at the time of closing. Thus, the title policy has no obligation under a policy to clear title of unlisted encumbrances. A title insurance company issuing a policy of title insurance has two underwriting options when its title search reveals an encumbrance affecting a title. List the encumbrances in a preliminary title report or prelim, requiring the parties to either eliminate it or accept it as an exception to the coverage in a policy of title insurance to be issued, or insure against the encumbrances by writing over the encumbrance, i.e., not listing it as an exception, and assuming any risk of loss connected to it. When title companies write over a known encumbrance, they usually demand an indemnity agreement from the person responsible for eliminating the encumbrance. This encumbrance typically takes the form of a money lien, such as a mechanic's lien, money judgment, or blanket encumbrance. Thus, the title company can recover a third-party guarantor if a claim by the insured is later paid to the encumbrance. Additionally, a title policy is not a representation, guarantee, or non-existence of the encumbrance that are not listed in the policy. If an encumbrance is not known on the named insured, such as the buyers or lender, and is not listed in the exception policy as an insured's claim against the insurer for money in excess of the policy limits, cannot be based on the insurer's negligent preparation of the encumbrances excluded from coverage. Similarly, a claim on an erroneous prelim cannot be based on negligent preparation. However, a title insurer might intentionally write over encumbrances at the request of a seller. If the buyer is not notified the encumbrances exist, the insurer is liable for actual losses in the excess of the policy coverage. In this instance, the insurer breached the implied covenants of good faith and fair dealing imposed on title companies as a duty owed to the insured. Introduction to title policy forms. Okay, the title is purchased to assure real estate buyers, tenants, and lenders the interest and title they acquire is what they bargain for. A policy of title insurance is broken down into 6 operative sections, including the risk of loss covered, called insuring clauses, which are based on a completely unencumbered title at the time of transfer. The risk of loss not covered, comprised of encumbrances arising after the transfer of a known or brought about by the insured, called exclusions, which are a boilerplate set of title conditions. Identification of the insured, the property, the vesting, the dollar amount of the coverage, the premium paid, and the recording, called Schedule A. The recorded interest, i.e. any encumbrances affecting title, and any observable on-site activities which are listed as risks agreed to and assumed by the insured and not covered by the policy, called exceptions, which are itemized for all types of coverage in Schedule B. The procedures called conditions for claims might be named insured for settlement by the insurance company on the occurrence of a loss due to any encumbrance on title which is not an exclusion or exception to the coverage granted by the insuring clauses, and any endorsement for additional coverage or removal of exclusion or preprinted exceptions from the policy. Insuring claims. All right, we got about 3 more minutes of reading here, guys, and then we're going to head and wrap up the class, answer any questions that anybody has, and then get ready for commission boot camp, get the day started. Okay, so insuring clauses. Coverage under the broadly worded insurance clause of a policy title insurance indemnifies the named insured for risks of loss related to the title due to anyone making a claim against the title of the real estate interest, the title being unmarketable for sale as security for financing, any encumbrance on the title, and lack of recorded access to and from the prescribed property. Exclusions from coverage. All title insurance policies contain an exclusion section. The exclusion section eliminates from coverage those losses incurred by insured buyer, tenants, or lender due to use ordinances or zoning laws, unrecorded claims known to be insured but not to the title company, encumbrances or adverse claims created after the date of the policy, claims arising out of the bankruptcy or due to fraudulent conveyance to the insured, police power and eminent domain, and post-closing events caused by the insured. Schedule A data. All policies of title insurance on Schedule A set forth the property interest the insured acquired, the legal description of the insured property, the date and time coverage began, the premium paid for the policy, and the maximum total dollar amount to be paid for all claims settled. Exceptions to coverage. In addition to the policy exclusions, a policy coverage under its no encumbrances insuring clause is further limited by Schedule B exceptions in the policy. The exception section contains an itemized list of recorded and unrecorded encumbrances which are known to the title company and affect the insured title. While the existence of these known encumbrances is insured against the insuring clauses, they are removed by Schedule B as a basis for recovery under the policy. An ALTA policy includes a set of pre-printed exceptions setting forth risks assumed by insured buyers, tenants, or lenders, claims, and settlement. Lastly, a policy of title insurance includes a condition section. The condition section outlines the procedures the insured policyholder needs to follow when making a claim for recovery under the policy. Also set forth are the settlement, negotiations, or legal actions available to the title company before paying a claim. Owners' policies for buyers. Several types of title coverages are available. Ha! No more reading for me today. Yes! Pow! All right, okay. Whew! In the books, in the books, in the books. Okay, so we got to page 3, what do we get? 345? 345 to 365. So we did not read 20 pages today. That's okay. Hey, all of these tests are open book, family. All of these tests are open book, right? So if you download your PDF of the test, right, and then you take your test every 18 days, right, Daniel? You take your book, you open it up, all of the answers are in there. There's no reason to fail, right? Okay, good. So you can get signed up. He's like, I wasn't listening to what you're talking about. I'm tuning you out. So calpaces.com, get signed up, get those 18 days ticking so that you can start getting your license. But don't wait until then to start getting commission, earning commission, start working towards getting paid now, right? And we've talked about this. This is I talked to Gino yesterday, and I was explaining it to them. It's like, is this legal? Only in the state of California. Only in the state of California can you work as an unlicensed finder in real estate and generate commission by finding and identifying people who need to buy and sell real estate. So feel free to give me a call. I'll slap my number right up there on the screen. I've been pretty consistently getting calls from people calling me up about the school, saying that they want to practice and whatnot. My number is 951-691-7798. I probably won't pick up when you call me, but I will call you back. Kelly Urso, so excited to see you, family. Okay, so we've got Commission Bootcamp starting in 4 minutes. We're going to be live on Facebook. Amy Serpa's at the helm as usual, but we're adding some new leaders to the class, adding some new people around. Hopefully Kelly's going to jump on and teach us a little bit about something. All right, everybody, have a great day. We'll see you at Commission Bootcamp here in about 4 minutes. And don't be afraid to come by the office. Don't be afraid to give me a call. All of these classes are uploaded onto YouTube every day. They are free of charge. It's not like I'm going to charge you for something later. I want to get you involved. I want to get you in here. I want to get you to work. Okay, we're going to get to work right now. You guys have a great day. I'm going to stick around in Zoom for a minute to answer any questions that anybody might have. Wiley Freeman, Semper Fidelis family. So good info. I appreciate you for tuning in. Feel free to join us. We're starting Commission Bootcamp here in 3 minutes. We'd love the leadership. Christian Tikas, handsome. Good to see you. Appreciate you translating. It's dry, but you know what? He says, that was dry. That was a rough thing to translate. But at the end of the day, the reason why Commission Bootcamp exists, the reason why the Finder program exists is because we read the boring stuff that nobody else was willing to read. Okay, everybody have a great day. We're getting started right now. There are no questions in the chat, just Christian Tika saying, wow, this part is really dry. Everybody on Facebook, have a great day. Feel free to drop by the office. See you soon.